Hi, everybody. I'm immigration lawyer John Khosravi. Thank you for joining us on our regular Tuesday, 5 p.m. Pacific time show. Questions live about U.S. immigration law, fascinating area of law that I practice and talk and think about every day. Be coming every Tuesday to take your general questions for educational purposes only, so that you get an understanding of what's going on in the immigration system. And it could be a complicated thing, so we definitely want to help you learn more about that. We have a guide for those interested in marriage green card cases. These are fiance visas and the like, where you're in love and you want to bring a spouse or a fiance with you. It's a great guide. We wrote 40 plus pages called the Ultimate Marriage Green Card Guide. All you got to do is to download for free is go to marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. You can check it out there. We also give away free video consultations for those joining the live show. All you got to do for that is write a good question in the Q&A section and write consultation at the end of it, so that we know that you're interested in it. And if you don't have a question, you can still write consultation. Just don't repeat it 50 times like some people do, or else that'll disqualify you. But then we'll pick every 10 minutes for a 30-minute show a person to win to talk in private. We'll give information on that once you're chosen. So just put your questions. We're live on Facebook, LinkedIn, YouTube, TikTok, Instagram, and maybe one more place. We're all over the place. We can check out our archive and library videos on our YouTube page. Either search immigration talk. Both those names are used. Hi, join us on TikTok. And having said all that, let's get the show started. So we got a quick question on Instagram. And they transferred my case to the National Visa Center. We have received. Let's talk process. So when you submit an I-130 petition, this is a family petition. You're a U.S. citizen or green card holder. You're applying for a spouse, children, parents, siblings, something like that. Once it gets approved, they transfer the case to the National Visa Center. Now, for cases like brothers and sisters, adult children, stuff like that, but because those cases have a backup line, don't expect anything too soon. However, if you have a case that goes faster, for example, minor child care parent case, that's relatively faster. So it takes between 1 week to 6 weeks, sometimes, but now, which is the first step and the next step. So you start with USCIS real relationship with this relative abroad station. States, they go through consular processing. That's the general title for that program. Processing is dealing with the National Visa Center. They're an agency that collects all the initial documents that the government needs and open to in-person embassy interview appointment for the foreign national who's going to be doing a green card request. So, that transition from USCIS, the internal immigration bar in the U.S., to the Department of State and the agency within the center, there's a transition process that can take 1 2 weeks, 6 to 8 weeks. If it takes longer than 8 weeks, you definitely that. So if he's okay, the National Visa Center. One issue we have, and I've done videos on this every day. This major problem is mark that they're going to do the case and not through the embassy system. And because of that, even though the foreign relative doesn't have to go through the embassy, USCIS keeps the petition in the United States and doesn't send it out. And for you to make that request for them to send it out to an embassy overseas or a National Visa Center, you have to make a separate request with Form I-24, which costs a lot more money. It's a nightmare, big time nightmare if that happens. And unfortunately, because we get so many people contacting us, there's probably thousands of people every year, if not more, multiple thousands, we get this because they did the case themselves and they weren't aware how to come. So you want to check your I-130 approval notice. It says that the case is being transferred, which then turns into a headache and a big nightmare. But Kevin, just hope everything is well with your question. So let's take some questions on other formats. We got the great Invisilas. Hi, John. Immigration case. I know we're processing time. Can I do? We got to contact USCIS to let them know it's outside processing times. Second, Congress first is to say, hey, help me, this case is taking too, or these are all options they can get into. Next question is from Simon. Are affidavits the solution of prior presumption? So I'm not sure why there's a prior presumption of marriage. The situation where this typically comes up is someone applies for a tourist visa, and for a tourist visa, their worry is from the U.S. Embassy part that you're going to enter. Really quick, actually, before I get into that, please don't post the same question over again. We're going to kick you out of the group if you do that, unfortunately, because it overwhelms everyone's questions. Stay your turn in line. If you keep saying it, keep repeating it, my wonderful assistant will name the person. I'll go and kick him out of the group, unfortunately. So please don't repeat the same thing over again. It makes it hard to do this job. So going back to Simon's question, are affidavits enough to prove dissolution of prior presumption? Someone applies for a tourist visa, but I want to visit the U.S., and they say they're not going to stay in the U.S. Those tourists will come back. Their spouse is still at home, so it's a lie. They tell get the visa, and later on they need to talk with them about fixing that situation up. They come to the U.S., get married to someone else. They actually were married before they marry somebody, but it's in the record that we're married to overcome that. So you need to get a single certificate from your country that says you're not married or wherever it happened, which should be very hard to get. But that's how you overcome the presumption. Are worth much in that situation. Simon, I need to know about your specific facts of when presumption came about to see how to challenge it. But that's a typical scenario I've seen when someone lies to the embassy, says they're married or not. That's in the system. Country that says you're not married and all that kind of stuff. So that there. But thank you. Next question is coming from now. Thank you. All right, so some new questions. So I'm trying to fix Instagram up. Okay. Rustam says, is it normal to have an 11-year validity for a permanent resident card? 1 year. So typically it's about for 10 years. When you get your green card from Asylum, backdate the green card. They typically I haven't handled asylum related case in many years, so I don't think they do 11-year green cards, but I don't think it's normal. So I'd have to see it for myself and learn about it. It might be 11, but it should be correct. And you contact US about making that correction. Next question comes from my favorite seat. So no, you technically can't, but when you're dealing with the definitely not be getting driver licenses get it, and people who should be getting it, they're not giving it, saying some system. Particularly for a DMV, that you need to show that you have some way of getting a driver's license. A situation where if you're a driver's license special version, but generally for an immigrant, you need to have a work authorization of some kind, an I-94 that says you're work authorized, that to be able to get a driver's license. Anything goes. So if you want to give it a shot, it may work, but the fingerprint receipt is but it doesn't mean the DMV might not won't issue a driver's license. It's kind of a free-for-all when it comes to DMV. U.S. illegally without leaving the United States? No, unfortunately. So when you enter the U.S. and you want to get it, if you want to get a green United States, the process known as adjustment of status, lawful admission or paroles. You won't be able to help them. There's some exceptions of crimes. They're victims of, by you, for example, if I were against a child case. If they had a petition pending for them, like 2000, 2001 or something like that, there's always exceptions that are like 1% chance. But saying if you don't have those exceptions, they will need to leave the United States, and by leaving, they become subject to what's called a 10-year bar, 10 years. Now, there's a waiver of that 10-year bar, but you need to have a relative, a 3 or 10-year bar waiver. It has to be a spouse or a parent. You as a child, spouse or a U.S. citizen, you as a child won't be able to do that. So, other than I don't handle VAWA cases myself. But there's the Violence Against Women Act. Also, if you have children who are abused, this happened. I'm not an expert on that kind of case. that may be an option that could fix that situation if there is effect. Sahil asks, I received an RFE as a request for evidence. This is when USCIS says there's insufficient evidence, we need stuff. Asked you to resubmit the I-864 even though I sent it initially. So the I-864 is the affidavit form. This is for family cases to show that, unfortunately, it is normal that USCIS will request the affidavit support even though you sent it, even though all the paperwork is correct. Now, I haven't reviewed your documentation to see what's in the packet you sent them, so I don't know if it's normal or not for your case, or if it was valid, the request that they're making. But unfortunately, it is a typical thing we see where USCIS at least asking for a medical checkup, which you already sent, asking for an I-94 approval of lawful entry, which you already sent, and finally, they called my client marriage certificate, even though it was in the application. It was approved within 24 hours. Frustrating because we had sent all these documents. It was not I don't think that say they're missing documents. Just make sure you submit the I-64, submit it completely because they're like last at it, and make sure all the evidence, the tax pay stubs, W-2s, and all that kind of stuff to show that the affidavit support works is there to having big problems. The next question comes from Matt and Sarah asks, can I get a green card from a citizen? My father, a green card holder. Can I get a green card from mother? I don't know if you think, I don't know details of your background, but a U.S. citizen can apply for their parent, or a green card holding spouse can file for their spouse. Typically, in this kind of case, it'll be easier to file as a child, a citizen child filing for the parent, as long as you're 21 over. Marriage case from your father to your mom, but we talked about this earlier. Did your mom enter the U.S. lawfully if they're in the United States, or they have immigration violations, subject to any ban? Some way, but some others exist. Generally, can a citizen apply for green card for their parents? It depends on the facts of your background. Darren, I filed 2 days before filing for adjustment of status. Could there be any form of misrepresentation since it's not new immigration status? Daryl, definitely contact the office. In your case, no, we talk this privately. You don't have to ask some stuff here. But it's a weird situation to get the I-539 approved, change of status out of nowhere, but for adjustment status. But it's just I don't think there'll be misrepresentation because when you submitted I-539, that's way before filing adjustment of status. So it just there should be two different things. I've said that you never know with immigration. This is a weird situation, just how these I-539s get approved out of nowhere by itself. But it's not something that's would rock my boat per se, make me worried about misrepresentation. It's a weird situation, but you could file change of status, for example, go to school, and also have a adjustment case pending at the same time. They don't go against each other per se, and that's about it. Thank you. Let me take a quick question on Instagram. Bruce asked, I applied for adjustment of status while my asylum case was pending on a marriage with a green card holder, and it got denied. I understood I have to wait for my wife to become a citizen. Other than that, should I do anything? They said leave the country. Should I just ignore that? So, Bruce, this is a really important question. Issue that pops up. It's very, unfortunately, inconsistent in how USCIS is dealing with that. So, I'm assuming you filed for asylum while you still had valid status. So, let's say you enter the United States with a tourist visa. Before your tourist visa expired, you apply for asylum. Most USCIS field offices will deny that case if you apply for a green card based on employment, or in your case, based on marriage to a green card holder. If your spouse was a citizen, this would have been approvable. Now, I'm seeing more and more lawyers advertise your situation, saying they get approvals, come to us, we could do it. Very few USCIS field offices. And again, this goes to the inconsistency of the immigration system, that some offices will approve this case and most of them won't. And I get into this, and people do comments on Instagram and stuff saying, what's a lawyer like? You make a mistake here about this, or law is a law. It's easy. Why do you have to hire a lawyer? It's like there's huge inconsistencies in the law and how it is practically handled, that you got to be aware of the situation to avoid a denial like this. So that's what's happening there. Now, if you have an asylum case pending, and it's a valid case is pending with USCIS, for example, asylum office, you do not need to leave the United States. You're in a period of authorized stay. But I don't exactly know what your case stands, but generally, if you have an asylum case pending, you don't have to leave. And Bruce, my wonderful assistant named you as a raffle winner. Actually, we had two people. I missed the first one. So Beltran, you're our first one, and Bruce, you're our second one. All you gotta do is take a screenshot where you're watching this. With the screenshot, I can see your usernames. I know it's you, and email me at info@jqqlaw.com so I can send you the information about scheduling a private video consultation. For those just tuning in and watching the live show, we give away free video consultations. We got one more left, probably in 10 minutes or so. We're gonna name the person. All you gotta do is like and subscribe and write something, question, or just write consultation. My wonderful assistant and myself will name a random person in 10 or 15 minutes to have a private video consultation with them, and that's that. If you're interested in marriage or fiance case, download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. 40+ pages. I break down the whole process, giving you a good idea of what's going on before you even talk with an immigration attorney. Thank you so much. So let's jump into the next question. Blue Chip asks, why is it taking so long to renew a green card? It's been 3 years since I've applied. Unfortunately, it is just taking too long. They don't have enough staff. So there's two renewals they could talk about. One is a 10-year green card with Form I-90. Those are taking almost 2 years many times. U.S. status expects that. The worst one is Form I-751. So let's say you have a 2-year conditional green card. You want to get a full 10-year green card. USCIS just announced they're expecting those to take 4 years. 4 years for an I-751 to be approved. Out of control, completely out of control. This shouldn't be acceptable for something that takes 4 years for an I-751 removal of conditions, but that's the situation we're dealing with. There has to be lawsuits, there has to be hearings. This is not acceptable, but this is what we're dealing with right now. Deco asks, can you please tell me how becoming a U.S. citizen affected if I filed a visa for my kid as a green card holder? What could be serious issues depending on how you did it? So, for example, if you're a green card holder and you file for your spouse, I-130 petition, your minor child comes within that. But if you naturalize when that's happening, that's going to cut your child out of the case. Or let's say you have an adult child of a green card holder. There's different ways where your child, essentially, there's different formulas where your child can get cut out if you naturalize, become a citizen while the green card case is pending. Another reason why it's good to talk to an immigration attorney, because it's very complex how this stuff happens, not as easy as it may seem. So I don't know your child's age. I don't know when you became a citizen, when you filed the I-130, all this kind of stuff. So I need to know how it would affect your situation. But there's a possibility it could cut out the child and somehow they go outside the case. It changes their category, most likely, at least. And so it could cause a lot of issues. It could destroy the Child Status Protection Act if they go older, their ability to hold on to an age under 21, so they can have a faster case. That goes into more complexity, but it could affect it. You definitely need to talk to an immigration attorney it's too late now if you became a citizen, but if you haven't already, to plan it out and maybe cancel your citizenship case if it's going to affect it negatively. RP asks, my dad's a U.S. citizen. Can he apply for my brother to get to come to USA? How long does it take to get here? Well, there's different factors. A U.S. citizen can apply for the child as long as the child's a good background. But how old is the child? Under 21 or over 21? Is the child married or single? What country was the child born in? All these three factors create a lot of variance in how long it takes. For example, if your dad is a citizen and filing for a minor child, that case could take 1 to 3 years, depending how busy the embassy is in the country they're from. Judging by your name, it seems like you might be from India, which has huge delays in the embassy system. But let's say your dad files for your brother and your brother's married. That goes into the F3 category, which is much, much longer. And adding the India aspect to it creates even more aspects. Or maybe from Mexico or Philippines, where there's backlogs as well. So how long it takes, I don't know the facts of your case. It could be 1 to 3 years. It could be 10 to 15 years or something like that. So it depends on so many factors and pieces of information that I don't have here. But those are things that help you figure it out, what you need to look for. So definitely talk with them, immigration attorney or private, to make the best decision. Now, Fiza says, my parents came in illegally. I'm a born citizen, a way to help them. Well, now, Fiza, we talked about this in detail about 5 minutes ago, but essentially it depends on some exceptions if they exist. Victims of crimes, victims from you abusing them. If they have what's called a 245I exception, and stuff like that, it's gonna be hard, but it's best to talk with attorney in private to see if there's a unique situation, has some exceptions. I'm going fast over this, but they're just tuning in because we talked about this for like 5 minutes earlier, so I don't want to repeat stuff that people already heard. You always check out the recording of this that's there. Americana asks, petitioner's spouse was a green card holder when he received a 10-year green card by petitioner. Petitioner's spouse was a green card holder when he received 10-year green card by petitioner's husband. And she became a citizen, and can her husband apply for citizenship on a 3-year rule? So it's kind of weirdly worded here, but essentially, if to be able to apply for citizenship based on the 3-year rule instead of the 5-year rule of waiting, you have to have been married and living with a citizen for the last 3 years. So you got to count when the spouse becomes a citizen, and the 3 years starts counting from there. And once it hits 3 years or 90 days before the 3-year mark, if you satisfy all the other requirements for citizenship, yeah, you can use the 3-year rule. But if you're both green card holders and you had your green card, then the spouse becomes a citizen. Potentially the timing won't matter because by the time 3 years counted from when they become a citizen, you're just going to hit the 5 anyways. Let me see anything on TikTok. No. All right. So Laura asks, what's some good evidence for married couples, military husband deployed, never lived together, a few pictures? So, you can download the Ultimate Marriage Green Card Guide or have a list of these. But for marriage cases, for military personnel, there's a lot of information. So when your spouse is a military person, you have like the health insurance stuff, the TriStar, Tri-something insurance. You have life insurance paperwork. You have a spouse of a military person ID card many times that you could use. There's a lot of different military-related spouse stuff that you have as documentation. You also communicate with each other, maybe on WhatsApp and stuff. You have screenshots of those that could be sent. You have letters from family and friends that can attest to a relationship. You might have bought gifts that you mailed to each other, make use as evidence on that you sent each other stuff. You may have created a joint bank account, for example, or some other stuff. So there's a lot of things going on that can help you show that you're a real couple, especially in military spouse cases. It's like there's a lot of military paperwork for spouses that comes up. That really helps those kind of cases. We do provide free consultations to active duty military members. So, Laura, just email the office with evidence that your spouse is in the military, and myself and my associate can have a free chat with you about your case to see what's going on. It's all done by video, Zoom video. But again, we do provide free consultations to active duty military personnel. Just got to show us you're really military, but that's about it. So email us info@jqklaw.com. We can take it from there. Sammy asks, hi, Mr. John, could you please explain for us about 48-month extension and what should we do about process still increasing? What are your actions as a lawyer for I-751? Is there any timeline for you to do something? You can sue them. That's the only thing. These I-751 removal conditions I talked about earlier, they say they're going to take 4 years. My cases all take between 6 months to 2 years, but they say they're going to take like 4 years. There's nothing you can do directly with USCIS to speed it up other than filing a lawsuit for delay. And that'll probably work because they don't feel like dealing with the lawsuit, not guaranteed. But if you're looking for what a lawyer could do, that's what the option would be. And Marie asks, I have a 10-year green card. Can I marry my boyfriend who overstayed his visa? We could get married. They don't look into immigration status when you get married. But because he overstayed, he's not able to adjust status based on regulations if married to a green card holder. So you're going to have to naturalize first, become a citizen, a spouse of a citizen who overstayed and satisfies all the other requirements, can adjust status. So there is the aspect we have to become a citizen first. But if you need to get married, then that typically is not an issue for most states. The reason why I say most states is immigration is not a reason that could prevent you getting married. But there was a story, 5 or 6 years ago where this person went to get married in Louisiana, and the judge asked about immigration status. And once she found out the spouse didn't have status, she called the police on them and ICE on them, which is a really nasty situation to do for the judge, but hey, they did that. But it's not that typical situation. It was so over the top that it came to us. Osman says, I'm a spouse immigrant interviewed yesterday for naturalization at USCIS. Passed the test with decision pending. I live outside the U.S. for more than 1 year. I'm a rich parent. What could be decision? They're probably going to deny your case if you were outside the United States for more than 1 year, even with a reentry permit in the last 3 or 5 years. So they would have brought that up at the interview. That say you got absences for 1 year, so that comes that automatic denial, unfortunately. Mohit asks, is it safe to travel with travel document and file a case pending? Safety is relative. I can't provide any guarantees, but if you have a proper document, most likely it's okay. But I don't know the details of your case, how strong a case it is, if there's a chance of denial when you're outside, or other issues from happening. So I can't give advice as something safe to someone I don't know who's anything about their case, unfortunately. Akash says, is it possible to apply for a green card through a B1, B2? So you don't apply for a B1, B2. A B1, B2 visa is a tourist visa to enter the United States. That's it. So if you want to apply for a green card, if you have a valid status or something, you potentially can. Your question is just not helpful. So we need to apply for a green card, you have to have a family member, employment, or something like that, and you have to satisfy a bunch of other regulatory requirements. So the B1, B2 visa just allows you to enter the United States with the potential option of applying for a green card in the United States as opposed to the embassy. Maybe But that's as far as it goes to helping on a green card. Getting a green card is a whole different thing that you need to handle and look into. Walnut says, "Do I need to all those? Do I need all those documents for I-134? Or can I just send it with a work letter and pay stubs?" So the form I-134 is like an affidavit of support, but not for non-immigrant visas. It's really all over the place what they want and how the requirements are there, and so it's a mess. But just do as much as you can do. That's the best advice to give. The more the better. Mel asks, "Hello, can you apply for an H-1B with an employer if I-360 has been pending for 29 months? The prima facie letter was renewed recently." So the VAWA case is on its own; it doesn't matter. But for you to apply for an H-1B, you have to either have a maintained status, or you can change the status from whatever you had. And if you had an I-360 pending for 29 months, you probably don't have any underlying status right now. Alternatively, leave the United States and do consular processing, but you got to make sure you're not going to be subject to some sort of bar. So it may be possible H-1B, but there's a lot of protective measures and information I need to know to make sure it's done right. You probably won't be able to do it, frankly, but you might have a small chance of having it. But I need to know more information about what immigration status you maintain, or if you want to take the risk of leaving and coming back to the United States to get the visa. Um, it's up to the employer if they want to go through the hassle and you want to risk it. But there's a lot of discussion that has to be had to make sure you make the safest decision. Family says, "My wife is a U.S. citizen and she's planning on inviting one of her relatives so that she can help her with the baby. Can she invite her using a DS-260 for? How long does it get the visa?" So this is a misnomer we get a lot. There are no invitations. This is not something to help. A person who wants a tourist visa applies for DS-160 on their own. They do an interview and it may get approved. How long does it take? It could be a week. It could be 4 years. We have some embassies that will do an interview really quickly and issue a decision quickly. There's some embassies that are backed up. They don't have a tourist visa appointment interview for 2 years. And even then, when you go there, it might take a year for them to make a decision. So it's all over the place. And with the idea of coming to help, some embassies will deny the visa because they'll say, or even at the border, when you come to the airport, they'll deny you and send you back. But they say, well, that is a job that a U.S. babysitter can do or a nanny can do. Why? That's unauthorized employment by having someone overseas come here to help you with the baby. They're taking away U.S. citizen or green card holder person's job. So that's a violation. That's some interpretation of some immigration officers. So there's a lot of issues involved in doing that, but it is what it is. Well, one quick question. Bruce follows up: "Can I update or upgrade adjustment of status after it gets denied, or should I follow another?" There's no update or upgrade if your case is denied. You could appeal it for some reason if you have a good appealable decision, but you may need to file another one. That would be probably the way to go. And KS asks, "Green card holder, after filing N-400, they travel outside the United States." Yeah, if you have a citizenship case pending, you could travel outside the United States. Just don't do violations by overstaying for such more than 6 months or stuff like that. But generally, you're not restricted from traveling. It's just if you have long trips, that becomes a problem there. Marilla asks, "My niece has an deportation signed by a judge. Can she appeal within 30 days? Asylum case." I don't handle court cases. I don't handle asylum cases, so I don't really want to get into talking about a situation like that. But I'm sorry that she has that order. But talk with an immigration attorney in private. That's the best thing to do about that. It's a serious situation. Really quick, no, okay. Deco asks, "I had filed for my daughter while a green card holder. She was 16, got her I-130 approved. The case at the embassy, and she did an interview. Now she's over 21. I got my citizenship. What happens to her visa category?" So that's the situation we talked about earlier about people messing up their case by naturalizing. By becoming 21, while that happened, you reset her into another category and reset the priority date as well. It's a huge mess. Deco, you need to talk to an immigration attorney in private to see what's going on there, because to have maintained the child under the age of 21 for immigration purposes, you were not supposed to naturalize by become a citizen. You change the category they're in, and they've said that that could lose your position as a minor under 21 and resets your timelines and stuff like that. My assistant Katrina named you as a raffle winner. So Deco, take a screenshot while you're watching this so I see it's you, and it's info@jqklaw.com, and we'll schedule a private chat about this, go into more detail so I can see the paperwork as well, the dates that you have and all that kind of stuff, date of birth, interview date, I-130 approval date, all that kind of stuff, and citizenship naturalization date, all that kind of stuff. But I think we'll take one more question and we'll call it a day. We have 30 minutes. We'll be back in next Tuesday. Really quick, Paranoid Android is on. I've been meaning to talk to you. Hopefully you're still watching. You had asked a question on our special Christmas show, Paranoid Android, about the H-1B L1 and O1 about dual intent. I made an error there. So H-1B and L1 visa allow you to travel while you have an adjustment of status case pending, Paranoid Android. without getting advance parole. O's don't allow that. However, there is regulation that says, and there's dual intent for O1. I made an error there about conflating these two concepts. So if you have an O1, H1B, or an L1, you can file for a green card case and have no issues regarding dual intent. Hopefully you're checking this out, Parent Android. Your question is, what are the 1 and 2 pros and cons for green card holders considering citizenship? I come from a country with excellent universal health care and law and crime, and I don't want to lose my birth citizenship. So, Parent Android, quick follow-up to make sure you're still watching. I've been waiting for you to come back on the show to tell you about that little quick error I had. Well, your other question, what are the pros and cons for a green card holder considering citizenship? Well, for citizenship, you could vote. There's not much. If you have a good citizenship for another country, unless you're patriotic in some way and you want to vote and take part in the American civics process, then that's good. But other than that, the most important thing is when people have a green card, there's a risk that their status could be taken away. So we have people here for 20 years on a green card, then they get caught up, they might be using drugs, they might get 1 or 2 or 3 DUIs all of a sudden, they're getting divorced, they're upset, depressed, they start drinking and driving. These are the things that cause you to lose your green card, or they might get caught with some marijuana or something. These are things that lose your green card. So one of the main reasons for getting citizenship is to clean that and avoid those kind of problems happen if you get involved with criminal kind of situations. But other than that, the pros of it, you can vote or something like that, and you can stay outside the United States for extended period of time. So I had a consultation yesterday, actually, for a couple that had this situation. They have great citizenship in Europe where they could travel and work there, but they need to be outside the United States for like more than a year because their family member is sick and they got to take care of them. But if they leave too long, there's a chance of losing the green card. So by becoming a citizen, those extended absences from the United States are not a problem where they are if you're a green card holder. So it's you got to see what's going on in your life and what you plan on doing and going in your life, both long-term travel purposes, but also for just decisions on where you want to live and stuff like that. Or if you're getting involved in criminal activity, then you know what the situation is going to be. So it's a personal decision. A lot of people are really proud to become U.S. citizens, and I understand that. But if you got, for practical purposes, if you got good citizenship in another country, unless you travel, getting a citizenship isn't that helpful, other than the fact that if you want to have extended absences abroad, or to protect you if you end up doing criminal stuff later that can be problematic and that could lead to your green card taken away. But thank you everyone for joining. Parent Andrew, thanks for following up. I've been waiting a couple of weeks to follow up. I hate making mistakes. I didn't want to correct the record, and I corrected it on the show comments for that one. But I always try to get the best information possible. As I said, everybody, thank you so much for joining. We'll talk to you all next Tuesday, 5 p.m. Pacific time. If you want to schedule a private consultation, talk about your case, there are fees involved, but email our office, info@jqqlaw.com. Briefly describe your immigration issue, and me or one of my associates can talk with you about it to take it from there. So next one, God bless, be safe, talk soon.